Hello and welcome to a brand new video on the subject of easements. This was a topic that was requested by a subscriber to my newsletter, and it felt like a bit of a gap in my landlord coverage, so here we go. The first question to get out of the way is what exactly is an easement, and the basic definition is it's a right to use property without owning it. So the most obvious example is a right of way over land, but often in problem questions you might see it cover other things as well. So things like a right to park on a piece of property or something like that. But yeah, that idea of using property without necessarily owning it, and that's where easements come in. As for the legal definition, we can go to the 1955 case of Re Ellenborough Park, and there are sort of four headings or four key aspects to the legal definition of an easement. The first of these is that there has to be a dominant and a servient tenement or piece of land. The second is diversity of ownership. Third is it must benefit the land. And the fourth is it must be the subject of a grant. Now, that all sounds a little bit complicated, but we'll go through all four of these in turn and hopefully make it a little bit more simple. So the idea of a dominant and servient tenement here, we've got the dominant tenement at the top, and that's the house, and this house wants to have access to the road along the bottom. In order to do that, it has to go through the servient tenement, or that servient piece of land at the bottom, and so the dominant tenement has a right of way across the servient tenement in order to get to the road. And that's all we're talking about here. There's going to be two pieces of land in question. One's going to be the dominant tenement, which is going to be the one that uses the easement or uses the right of way, and then there's the servient tenement where the right of way is across that piece of land. Secondly, there has to be diversity of ownership. This is very simple, just the idea that the dominant tenement and the servient tenement, which we saw in the last slide, they have to be owned by two different people. It doesn't really work if it's just one person who owns all of that land, because obviously they don't really have a right of way. They're just travelling across their own property to get to the road. So yeah, diversity of ownership is the second aspect from Re Ellenborough Park. The third is that it has to actually benefit the land rather than the owner or what the owner is doing. So Hill and Tupper is a good example of this from 1863. It actually deals with a profit rather than an easement, and we'll get onto the difference between the two of those at the end of this, but for the time being it's easy enough just to think of it as the same thing. The person was using the land in a way that basically allowed them to run pleasure boats on a canal owned by another person. And the question was, does that count as an easement? And the idea was that what the court said was that no, it's not an easement, because really it's about benefiting the business or benefiting the owner of the land rather than actually benefiting the land itself. Now, this is interesting because it's in contrast to Moody and Steggles, which is the second case I've put up there. And here the right was to put a sign up for a business on a piece of land. And you might be thinking, looking at the last case, well, that sign isn't really an easement as such because it's really benefiting the business or benefiting the owner rather than benefiting the land itself. But surprisingly, the courts held that this was an easement because it was sufficiently connected to the land in order for it to be considered an easement in that way. So we've got a couple of cases there that almost seem to contradict each other. And I think the idea to take away from this is that the idea of what is benefiting the land rather than the owner, it's not really clear in the law. So definitely something to discuss if it comes up as a problem question. The final point on this is just to say that the two pieces of land also ought to be fairly close together. We've seen in the graphic example earlier that the two pieces of land are sort of literally connected to each other, like they're adjoining. Whereas if you came across a case where, say, the two pieces of land were a couple of miles apart, then an easement isn't really going to apply there. So the final point that we're talking about is it must be the subject of a grant as well. And what we're really talking about here is that the right in question, or the easement, should be sufficiently certain. So going back to our classic example, the right of way is a clear path that leads from the house to the road, and so it's very sufficiently clear. However, in Aldred's case from 1610, we saw that the right to a view is not certain enough to form an easement. So that certainty is also really important so that the courts can adjudicate on it. So that is the 4 essential elements of an easement as it was defined in Re Ellenborough Park. But before we move on, there's actually also some other rules relating to easements that it's worth being aware of. In the first instance, easements should not impose obligations on the owner of the servient tenement. So in Regis Property and Redmond, we saw that there was no obligation on the owner of the servient tenement to supply hot water or heating to the dominant tenement. Also, in a similar fashion, the easement should not restrict the rights of the servient tenement to deal with their own land. And we saw in the case of Phipps and Pez in 1964 that there couldn't be an easement that would prevent the owner of the servient tenement from choosing to demolish their own property. Also, the easement must not amount to exclusive use of the land. We saw in the case of Copeland and Greenhalgh that parking a car that blocked the road basically created an exclusive use of the land, and that's not really what this was about. The use of a right-of-way, for example, is maybe something that you might use a few times a day and you might come and go, but parking on the land, especially if it prevents ownership or use of the land in other ways, or prevents the actual owner of the servient tenement from enjoying their land, then that is not going to be allowed. And finally, an easement cannot later be used for different purposes or have its use intensified. So this was a classic example of another right-of-way again, but in Gelbert and Davis what they tried to do was use that right-of-way as a caravan site. And clearly that's completely different from using it as a right-of-way. It was intensifying the use, using it in a way that it shouldn't be, and so the courts didn't allow that. So one of the other important distinctions that is going to be relevant when we're talking about how these easements can be enforced in relation to third parties is that there is a distinction between a legal and an equitable easement. Now, a legal easement is simply created by way of a deed, and an equitable easement is created via a written agreement. So an important distinction there. All of this makes a difference when it comes to actually protecting the easement. So for unregistered land, legal easements are binding on all third parties, whereas equitable easements must be registered as land charges. The situation for registered land is a little bit more complicated, but not too much. Legal easements are registrable dispositions, and equitable easements are minor interests in the property. Now, legal easements will only be overriding, in other words, they will only be binding on purchasers if they were either created before the 13th of October 2003, they were created by implied reservation, by implied grant, or by prescription. And again, that might not mean much to you now, but we'll go through each of the 3 of those in turn. So implied reservation is basically either necessity or common intention. And these are actually both very rare. So in Adelon International Corporation Propriety Limited and Merton London Borough Council from 2007, we had a situation where a claim failed even though there was a request for access to a public highway. So the necessity in question, the courts are asking in this situation, is the easement necessary? And you might think that something like access to the public highway, like we've seen in our own example, is something that would be necessary. But in this situation, it was held that that was not the case. So there's a really high threshold for necessity in these types of situations. So don't just assume that an easement in your own example in a problem question will be solved by necessity. On the other hand, we have the case of Wong and Beaumont Property Trust Limited. Here there was a case involving a Chinese restaurant, and there obviously needed to be filters and things to reduce sort of like the smell in the area, and it was necessary in that situation for access to the landlord's property. And there was a question about, well, this wasn't specifically written into the agreement. However, it was said that by the courts that there was a common intention to create this ventilation system, and so access to the landlord's property could be granted. So there was a common intention between the parties that the courts were able to read into. It's kind of a bit similar to necessity. Maybe it's a little bit easier to get to, but in order for the lease to make sense, there had to be access to the property. Next we have implied grant, and this is sort of split into two further subcategories. So the first of these is the rule in Wealden and Burrows from 1879. And it basically says that when there is a grant of land, the buyer will acquire all the easements which are continuous and apparent and are also being used by the seller for the benefit of the land at that particular time. And normally it's also going back historically as well. So we can look at another example here. We've got our house that's close to the highway and we've got a right-of-way across it. At the moment, this land is all just owned by the grantor. But normally what you'll see, and the thing to look out for in Wealden and Burrows examples, is that the land will actually be split in the course of the question. So there will be a grantor, and part of the land will be sold to the grantee. And the question is all about whether this right-of-way that exists between the two continues to exist. And the courts in this situation in Wealden and Burrows say that yes, it will do, because there's been a grant, and the continuous use of the right-of-way will still remain. And that continues even if the grantor splits the two pieces of land to two completely new people. So the grantor sells the land and splits it between A at the top, B at the bottom. That right-of-way will still continue to exist. The other type of implied grant comes from section 62, subsection 1 of the Law of Property Act 1925. And this basically says that when there is a conveyance of land, that any easements are also conveyed as well. So it's a pretty simple concept, but the way that this has been interpreted by the courts is actually a little bit controversial. So in the case of Wright and McAdam from 1949, there was a license, or in other words, a simple permission, for a person who was renting a building to store coal there. Now, what happened was that there was the tenancy came up for renewal, there was a brand new tenancy, and that was counting as a conveyance. And what the courts decided was that as part of that conveyance, section 62 subsection 1 triggered, and it converted what was simply a license or a permission to store coal into an easement. And this was obviously a little bit controversial because there's much greater protections for an easement than there would be for a license. So this is certainly an area of the law where the Law Commission has recommended that this just be scrapped entirely, and there's been a lot of criticism of that case. So if something similar came up nowadays, it's very possible that the courts would look at this situation a little bit differently. But for now, section 62(1) allows for easements to move upon a conveyance, and potentially even for licenses to be converted into easements as well. Finally, we also have prescription, and the idea here is that these are easements which aren't official in any way, but they exist by virtue of long-term use. So we've got this case from 2011, London Tower Hotel Limited and Kensington Close Hotel Limited. These were two hotels that were next to each other. There was a service road that was between the two hotels. It was owned by one of them, but both of the hotels made use of it. And it wasn't very clear that the road was actually owned by one of them. And over a period of more than 30 years, that road had just been used by both of the hotels, even though one of them owned it and one of them didn't. Now, it got to a certain point where the hotel that owned the road tried to enforce their ownership and prevent use of the right-of-way. But what the courts essentially said was that this right-of-way had existed for such a long period of time that it basically became crystallised into an easement. Now, these easements by prescription, they have to be without force, without secrecy, and without permission as well. And the interesting thing in this case is that there was an argument that this was existing with secrecy as well. In other words, the hotel that didn't own the road was using it in a secretive fashion. But that was held not to be the case because at any point the hotel that did own the service road could have made inquiries and prevented use of it. So, as I say, this idea that the service road, it's been there for 30 years, they could have made inquiries, they didn't, so the easement sort of grew up out of long-term use rather than being official. Now, these easements by prescription can come about in three different ways. Firstly, we've got common law, then Section 2 of the Prescription Act 1832, and finally lost modern grant. And if you're approaching this in a problem question, I would normally do them in this order. Common law is certainly very rare, and lost modern grants are a little bit more common, but it's important to sort of go through each of them in turn. So we'll do that now and sort of give a bit of an explainer for how each of them works. The first of these is the common law, which is the idea that the easement has existed for time immemorial. In other words, for as long as we have actually had the common law system since 1189. Now, this is obviously going to be very rare because if you imagine, there's probably no houses at all that are still existing since 1189 that are still around today. So this is probably only going to concern maybe 2 pieces of farmland, and it goes back for years and years and years, centuries. There's historical records of the easement that exists, but realistically this is only going to be applying a very small number of cases throughout the country. A little bit more common is where Section 2 of the Prescription Act 1832 applies, and this is where a claim to an easement requires 20 years of continuous use. If the easement is instead based on an oral agreement, then it requires 40 years of continuous use instead. So this is like a much shorter term in terms of compared to common law, but we're still requiring continuous use of an easement over a period of time, and then Section 2 of the Prescription Act 1832 kicks in, and there will be an easement there. The final one is the lost modern grant, and this is where an easement has been continuously enjoyed without force, secrecy or permission, those 3 categories that we talked about earlier in relation to the hotels, for 20 years. And at that point, the courts will assume that an easement has been granted, but it was lost. So again, this idea of prescription is sort of like, has there been an easement there? Maybe there wasn't an official agreement, but has it existed for such a long period of time that the courts will step in and simply say, yes, there is enough evidence to say that there is an easement there. Finally, this is the last slide now, and all I want to say about this is that easements and profits are often sort of thrown together. I've focused this presentation on easements because, it's easier just to keep to one topic, but profits are very similar. The idea here is that it's the right to enter onto land in the same way that an easement is, but a profit you will actually be able to take something from the land. So you might be able to go in and cut down trees and collect timber. You might be able to take your cattle onto the land or allow them to eat grass, so you're taking something from the land. It's a little bit more than a simple right of way or an easement. Or you might even be able to go onto the land and carry out fishing or something like that. So profits and easements tend to fall into the same category. Profits are a little bit more serious because you're taking something from the land. They also operate in a similar way, so most of the things that we've talked about in this presentation in relation to easements will also apply in relation to profits, but here there's no requirement of a dominant tenement. The rule in Wealden and Burrows does not apply to the situation with profits, and the prescription periods are also longer. So under the Prescription Act we talked about how it was 20 years or 40 years for an oral agreement, and the situation for profits is it's 30 years or 60 years with an agreement that is carried out orally. So that concludes the presentation on easements. Hope you found it useful. If you do, remember to do all the like, comment, subscribe, all that sort of good stuff. I think if this comes up in an exam, one of the things that you can talk about is definitely sort of how there are proposals for reform around this area. There's a lot of confusion about sort of what should count as an easement and whether the rules on prescription are fair or not. And the Law Commission's done a lot of work about how the law should be reformed, so definitely a lot to talk about there. Similar thing for problem questions. There is going to be sort of cases where, is there actually an easement here? We can talk about things like, was there actually necessity here? If there isn't, is there other ways that an easement can be established between two pieces of land? If we're looking at a piece of land that has been split, then you're probably going to be looking at the case of Wealden and Burris for that. But yes, you can sort of follow this, give the definition at the start, and then work through the problem question and try to establish the easement and provide arguments for both sides to say, is there an easement or is there not an easement? I'll be back with another video, I'm sure, at some point in the future, but for now, bye!